Hello and welcome. My name is Brian Fellner. I'm an attorney with the law firm of Fellner Legal Services. We represent community associations, condominiums, homeowners associations, and cooperatives throughout Maryland and the District of Columbia. Today I'm going to talk to you a little bit about racially restrictive covenants and how to get rid of them. Perhaps you're surprised to learn that racially restrictive covenants still exist. Perhaps you're not. In either case, this is still a simple fact of life, and it's something that continues to exist within the community association realm. HOA condo documents are often prepared and recorded in land records and are there for a long time without amendment. This is for a couple of reasons. First of all, the amendment process is often onerous and difficult to accomplish. You need a certain percentage of the owners to vote on that amendment. You have to go through drafting and recording and other things of that nature. Second is simply the interest or lack thereof in changing those documents. A lot of the times what exists sits in land records for many years, and the community is able to function and accomplish what it needs to simply by passing rules and regulations within those documents, within the parameters that those documents set. In any case, a lot of the times those homeowner association documents will be on the books for many years, will be on file and with land records or the recorder of deeds in the District of Columbia for decades. And so often they have provisions that are no longer valid for any of several reasons. There's legislation that's passed since then. They're out of date. They talk about phone lines and other things from our past that no longer are relevant. One of the things that still exists in some of these documents is racially restrictive covenants. And these were used over the course of many years in our country's history to restrict, based on race, who could live within certain communities, certain associations, certain neighborhoods, and to hold people of color down. That was their purpose, plain and simple. Obviously, the Supreme Court, federal legislation, and the actions of most, if not all, states have invalidated those covenants. They are illegal. You cannot enforce them at this point, but they still do remain on the books in certain places. Story time. When I was a younger attorney, learning community association law, reading HOA covenants, documents, and finding out all these things for the first time, I came across one of these. I was reading a set of HOA covenants, the declaration I had pulled from the land records within Maryland, and I read one of these racist covenants. And my reaction was to laugh. I said, in this day and age, obviously that's unenforceable, and no one would ever even try to make use of such an onerous provision. Wrong. That was wrong, young Brian. And it was wrong for a couple of reasons. First of all, as we know, that was absolutely an inaccurate statement about our society today. There are still people who would make use of those. There are still racist people. So to say, oh, there's nobody who would ever care about this document is flat out false. The second problem is, regardless of whether or not it's ever going to be used, no one should have to live in a community association where that document is still on the books that purports to discriminate against them based on the color of their skin. That simply shouldn't be a thing that has to exist. I can't put myself in that situation. I can't say I can understand what that would feel like, but I sure know that I don't want it to exist, that I don't want people to have to live that way. So the Maryland legislature saw things the same way, and in 2019 they passed pretty admirable legislation to try to take care of some of these problems. And what they said was that, notwithstanding the provision of the governing documents, so no matter what it says about amending the documents and you need 2/3 of the owners, or you need 60% or 80% or what have you to vote, or anything else like that, a community association board by itself can remove racially restrictive covenants based on a simple board vote. They can amend those documents and take out those racially restrictive covenants. Not only that, the legislation also says that if an owner in a community association with these covenants on the books brings that issue to the board is obligated, they are required within 180 days to amend, to take that action, amend and remove those racially restrictive covenants, and record that document, that new amended document, with the land records in the county where that association is located. Similarly, the District of Columbia Condominium Act provides that no restraint on alienation shall discriminate or be used to discriminate on the basis of religious conviction, race, color, sex, or national origin. So once again, those provisions provide that anything in your community association documents that says or purports to discriminate based on race is invalid, and also it can be cut out and it can be amended out. And the process there is a little bit more up in the air, but that exists. And that's why it is the policy of this law firm that if any community association board contacts us and asks the process or asks for an amendment to remove those racially restrictive covenants, we'll provide it to that board, including instructions on how to record it, at no charge, no fee, no strings, anything else. Similarly, if any resident of a community association comes to us with that request and says we have racially restrictive covenants within our association and I need to take something to my board, we'll provide you with a draft to show to your board, again at no charge, no cost, no fee, no obligation, no anything else. Now if that sounded like a lot of legalese, but it seems like something that might pertain to your community, you can feel free to reach out to us for more information. For me, and for in the community association world, I think this is the functional equivalent of tearing down those racist statues that are out there, that have been defended for a while, that seem to be an anachronism, but that are still there, and that shouldn't be anymore. My name is Brian Fellner, and my law firm is Fellner Legal Services, and our motto is service, success, simple.